Francis Collins on the same topic, and also from other members of the establishment. There are people who direct these agencies. But for the first time in my life as a faculty member, they're saying things like this. It is now essential to document with solid evidence the returns our nation is obtaining from its investments in research and development. And I'll stop right there. 1948 or so, Vannevar Bush wrote the Endless Frontier of Science. And with that started really an era of scientific enterprise in universities around this nation, which was absolutely unprecedented and led to enormous amounts of innovation and education of people in the sciences and engineering. That is really something that most countries around the world seek to emulate to this day. This is the first time, however, that I can remember government agencies actually seeking to measure and document effectively the economic impact of the research and development work that we do at the universities. And so he goes on to mention STAR metrics. Now, have any of you looked at STAR metrics? If you haven't, I suggest you Google it and take a look at it and take a look at what it seeks to determine. And the kind of thing it seeks to determine, just to give you a few for instances, are things like this. Number one, how many jobs did you create per dollar of federal research funding? How many new companies were started? What kind of licensing activity have you had? And so forth down the line. Much of these were put in place during the ARRA, the American Response and Recovery Act. And the reason for that was to justify the investments that the administration was making in science and engineering, and particularly at universities. But of course, once something is introduced, we all know it's hard to take it back out again. And STAR metrics is probably the least onerous of the kinds of reporting systems that have been suggested for universities at the federal level. So this really represents a change, and STAR metrics is, as he puts it, an important element of doing that. I have a long talk that I've given on this, and some of you have heard it when I talked about Let's Talk About Research, and you can see it online if you wish to. We did it in this room. But really, what they're looking for is for us to become the new engines of innovation, right? And as the new engines of innovation, then, we have to find ways to really transfer the products of research and scholarship out to the marketplace. Now, I want to stop right there for a minute, too, because oftentimes when we talk about these things, I find that people who are not in science and engineering want to know how they can participate. And can they participate? And the answer to that is absolutely yes. Probably one of our most notable successes here at MU didn't come out of science. It didn't come out of engineering. It came out of the journalism school, and it's called Newsy. And if any of you haven't seen Newsy, I'd like to ask you to take a look at that, because I think it's really a marvelous example of how a very little, small capital investment can lead to a very powerful new company that has enormous value. So this is really open to everyone, and at the same time, it doesn't have to be everyone. But I think in order to ensure that good dollar flow continues to our university, we need to pay more attention to this. So again, what I've found in the past is that, as an engineer and a person who's been in industry, I think I take for granted often how much I know about intellectual property. And I've worked on all different sides of it. I've worked for companies where everything was signed off for the company, and essentially I got my salary, and that was it. I've worked as a consultant under similar conditions. But at the university, things are different, because we share the inventorship, and we share the proceeds of intellectual property, if there are some, with you rather generously. So as most schools here at Mizzou, it's a third, a third, a third. So it's important as we go into this new era that more people, more faculty, and ultimately more grad students and postdocs really understand what intellectual property is all about, and how we do it, and why we do it, and what the value is. So without going on too long, I just wanted to say what we hope today to cover in brief, and it's just in brief, it's really just touching on the subject, is what is intellectual property, why is it important to you, why is it important to the university, and this is one of those reasons, and how you can find more information. Let me turn now to the panel and introduce some of the folks who are here, all of the folks who First of all, let's start with Joan Gable. Joan is the Dean of the Trulaske School of Business. Joan is also an attorney and brings together really law and business, and I think in a very interesting and scholarly way. I'll turn to Gary Myers, who is the Dean of the Law School, and Gary has sitting next to him two of his colleagues. We have Erica Lietzen. Erica is there, I think. Hello. Who is an associate professor of law, and Dennis Crouch, who's also an associate professor of law, both of whom have a lot of interest in intellectual property. I can't be more delighted that we have two deans here, two faculty members from the law school to talk about this. So thank you to all of you for being here this morning to participate in this with us. I'd also like to introduce Luis Jimenez. Luis is here. He has an undergraduate degree, I think, in chemical engineering and an MBA from Mizzou, from the Trulaske School. And he's one of the shining stars of this new generation of entrepreneurs who has taken and worked with faculty members here to create a company, and that company is on its way and on a pathway, I think, to tremendous success. So I'm very excited to have him here. And later in the program, you'll hear a bit from Luis about that which he has done and some of his experiences. But I have to be careful. I think I have to start checking names off because there's two lists here. So I've done Gary, Dennis, Erica, Joan. Let me turn now to Bill Turpin. Bill is right here. Bill just came back from a career on the road, so to speak, first at Texas Instruments and then in Silicon Valley. And he is now running the Missouri Innovation Center, which is our incubator. Bill graduated #1 in his class in electrical engineering, which I think is just a remarkable accomplishment in and of itself. And then he took that degree and went in a lot of different directions with it. And now, as CEO of the incubator, he's really there to take that experience and help us move things from the research laboratory to the incubator and hopefully then out to the marketplace. You'll be hearing from Bill today. Steve Wyatt. Steve Wyatt has been with us now for about 25 years. Steve has both a JD and an MBA. And recently I've asked Steve to take on even more responsibility. And so many of the people that you see on these tables, including Chris and Craig David, are now reporting to Steve. And Steve has a primary focus in economic development. And what I found is he knows everybody in the state. There's no one I've yet met in the state that Steve doesn't know. And so it's a tremendous resource for us. Let me also introduce Lena Nedlick. Lena, you can wave your hand back there. Lena is our new IP attorney who started, I think, last fall in General Counsel's office, and we're very happy to have her here. Also a chemical engineer by undergraduate training, so again, blending sort of technology and intellectual property law together in a very fruitful way. Chris Fender. Chris, you want to raise your hand? Chris is the director of our Office of Technology Management and Industry Relations. Craig David. Craig's back in the corner there. Can't hide Craig. We see him. Craig is running our Office of Sponsored Programs. And Scott Ullman. Scott Ullman is an assistant vice president with the system and oversees all of the intellectual property work that we do at the system level. So it should be a pretty good discussion this morning. I think we're going to try to give you a lot of information quickly. But again, we're going to just be skimming the surface. We won't be experts by any means when you leave here. But I hope that you'll have a better sense of what we're doing, why we're doing it, how we're doing it, and who the people are that you could get in touch with when, in fact, it's time to think about intellectual property in your own domain. So with that, does anyone have a comment they'd like to make at this point before I turn the podium over to Steve Wyatt? I'm guessing not, so Steve, why don't you go ahead? Thank you.
Thank you, Hank. Can everybody hear me okay? Good. Well, thank you for being here this morning. I appreciate it. Are we set? I think so. Okay, good. Once again, I'd like to thank you for being here today, and we hope to have a conversation to just try to increase the awareness of intellectual property for many at the university, and to constantly look for ways in which more and more individuals that want to explore different pathways see how that can occur. So So if we kind of start off with a large, in the large context, we think about the missions of the University of Missouri. So as most of you know, we have a strong research mission focused on continuing to improve our position in the AAU. That's a key component of who we are and what we're about. The second key mission of the university is instruction, teaching. It's where we work very diligently on trying to train many young people that come here, and in order to allow them to learn not only in their field but also a lot of critical thinking skills, interpersonal skill sets for them to be able to thrive in life. The third mission of the University of Missouri is really that aspect of service or extension or outreach where we, as a land-grant mission, try to take the knowledge and take it to the people. So on the one hand, we want to be an outstanding research institution, but we also have a passion from our inception to be able to take that knowledge to the people in order to improve the lives. And the fourth one, which is more recent, is the mission of economic development. That mission of economic development spans creating a top-notch workforce to go out into the marketplace. That includes licensing some of our technology in the marketplace. That includes helping to attract companies to the state, to improve our economy, public policy work. There's a whole host of things that we do that actually have a significant impact in improving the quality of life in our economy. So that's the big four missions of the university. And many of you as faculty go, well, that's all we have to do? That's a lot to ask, isn't it? That's a lot to ask from each faculty member. That's a lot to ask from each of us. And yet, those four missions actually work pretty well together, if you think about it. Through that research aspect, we're able to take that research and what we're learning and new knowledge and translate it into our second mission of teaching in the classroom. And here at NU, we also have the wonderful strength of having a lot of undergraduate research where we can actually include those students into that research process. And then, of course, we also have this desire to move it out and ultimately have an economic impact in society. Because one of the great things about discoveries, whether it is basic research, whether it's applied research, at the end of the day, we all hope that there is a way that does make it into society and it improves the lives of people, and we love the idea that occurs here at Mizzou and continues to raise the academy here. And that's a very exciting aspect of that. And because at the end of the day, we very much want to continue to move the ideas from the whiteboards of our labs to the boardrooms of many of our businesses and ultimately into the spaces and rooms of the lives of the people here. But like most things, those missions sometimes conflict. So as we think about that from a faculty perspective, you face tension between, do I spend more time on my research or do I do that extra preparation for the class that I'm about to teach? And both of them are important, but there is a tension, and we have to manage those and make judgment calls on when to invest here and when to spend our time in other places. Well, sometimes, from a faculty member, the research objective and maybe the economic development objective of trying to get that into the marketplace might have some tensions as well. And that is what today is really kind of about, is talking about intellectual property, and I think it's important for us to realize that there can be tension there. So let me explain what I'm talking about. So if you can imagine, you've been doing outstanding research in your lab, and you've been working very diligently. You now have identified a new discovery, a new innovation that you're very excited about. You start looking forward to the opportunity to put that together into a paper that you can get published in a peer-reviewed journal. That's very important to your career. You really want to tell everybody everything about that, because that's important. You also are working very diligently to go to a national or international conference to share with everyone all of this great information. that's fantastic. And we're all geared up and ready to go. However, we just pause a minute and think about it this way. We also want to get it to the marketplace. So that same discovery, that same innovation, we may realize that in order for it to really impact society, it's going to take a lot of money. It's going to take millions of dollars, especially if we're talking about a drug or something along those lines, where you may have to go through clinical trials, phase 1, phase 2, phase 3. There's some of the numbers I've heard, it may cost as much as $1 billion to take a new drug all the way through. It's a huge cost. So who is going to invest the money to do that? Who's going to invest in the perfection of that idea, the prototyping, the sales force, possibly creating plants, production facilities, and all of those things? Well, whoever is going to invest that much money is going to want to try to figure out a way that they have some protections or barriers so they can at least recoup their money for taking the risk to make that investment, right? That's an important part of it. And that's where, as a faculty member, the intellectual property becomes an important piece of that. Because whoever is going to do that, whether that is the faculty member themselves or whether we license that technology somewhere, is going to want to make sure that's protected so that they can deal with it and rationalize the investment. Now, you may say, well, that's all great, but I still have to get that out. Well, let me put it back into the context, again, of you having that discovery and getting ready to go to the conference and publish your paper. Imagine if through that whole process that all of a sudden somebody that happened to review your paper or see your presentation decides to edit it, make a couple little tweaks to it, and all of a sudden they decide to publish it underneath their name. And all of a sudden they decide to take your presentation and go speak at a conference with their name on it. How would you feel? You would be shouting from the rooftops, plagiarism, copyright infringement, all of those things. Why? Because you have invested your blood, sweat, and tears in that innovation. Right? Well, if, however, you put that out on the web and you said, I did all this work here. It's in the public domain. Go take it. They would be right to do that, right? Because you've given it away. Well, that's the way it is with intellectual property. If we do not, through that process, figure out how we can protect it, we have given it away. And then, in essence, what ends up happening as a company or an investor wants to invest in it, they go, well, what protection would I have? It would be very easy for somebody to copy everything. So that is where it comes in, this important aspect of collaboration, figuring out how we manage moving forward with publications, presentations, at the same time making sure we disclose those innovations, and ultimately figuring out a way to manage the protection of it, and at the same time allowing us to move forward. And therein is the tension. And in many cases, that's been done quite well. And in some cases, we're not able to protect it as the university and so forth. So that's an important piece of thinking about all of us as a team working together to figure out how we can best address the intellectual property and how we can also best address getting the knowledge out and into the marketplace. So that occurs many different ways, how we move it forward. The university has done such things as licensing technology to somebody else, and before they license it, they want to make sure that technology as well. We've done some internal operations. Many of you are familiar with Rail, where that grew up inside and ultimately was sold. We've done equity investments, all sorts of different things. But to create the value, there has to be a little protection, which is why Luis is here. Luis, you want to come on up here, and we'll just kind of have our conversation, if that works. To talk a little bit about how does that play out. So, for example, in Luis's situation, this comes back to some technology that was developed through the biodesign process, working with faculty member Dr. Sheila Grant. And so what I thought I would do is just ask Louise just to share a little bit about how your company has got to where it is, and then we'll start talking about some of the IT issues and so forth. So if you want to kind of give them just a little summary of Eternigen and how you got there, we'll go from there.
They want what I give them.
Oh, you have enough?
I think the microphone. Yep, I'll speak loudly enough. Good morning. It's a pleasure to be here. I am honored, I guess, to be introduced. I guess from the way I see it, I'm just living the dream. There's not much to highlight. As was mentioned, I was a student here at Mizzou. I love this institution. So many opportunities. When I came, I was kind of baffled to understand or to learn that there wasn't an entrepreneurial concentration in the BA program, something that hopefully soon will happen, but there is a certificate now. But I saw so many opportunities when I just visited the campus. I mean, classes, faculty, experience, IP, I mean, everything was here. Collaboration with the medical school, an engineering school that is very prolific, scientific community here. So I just thought, here's the place where I need to go. And the reason I was getting an MBA, and sorry to make it a little bit personal, but I think it's kind of part of people's motivation, is that I wanted to someday, in the future, after perhaps 30 years of experience, start a company. And my ambition was to someday be able to benefit my home country, which is Honduras, in a way of being entrepreneurial. But I never imagined that throughout my first semester of the MBA program, I was going to be able to collaborate with the faculty as supportive and innovative as Dr. Sheila Grant in the biological engineering program. I mean, it was just amazing that from the beginning, she's authored so many articles and had a couple of patents already applied for, and she was like, I think we need your skills, Luis. We need business skills. And I'm like, well, I'm getting them right now, and I'm willing to make it my best, and that's just a trait that I think as an entrepreneur, you just got to look at, I think the definition that I learned at Missouri Innovation Center at the incubator is that entrepreneurship is the willingness to do something without really regard to all the resources that it's going to take to make it. Just start in the pathway. And that's kind of what we did. We started putting together a business plan, negotiating the license from the university for the patent that allows us to stabilize collagen, the most abundant protein in the body, with nanotechnology. That's what Dr. Sheila Grant was working on for about 15 years. Throughout the process of negotiating the license, putting a business plan together, building a team, the results started to come to fruition. I think it's a synergy that has to be there. It's an ecosystem that has to move itself together, because if one of the verticals is not moving forward, it's going to be very hard to make the things happen. But they at one point all converged. And after my graduation, 2 months, I was kind of paying rent or credit cards. But 2 months after, we were able to close our first round of funding. That was in 2012, about $500,000. And to date, we've raised $3 million. We've secured a second technology into our portfolio. We've completed a clinical trial already in Europe. And our milestone was to get approval for our final clinical trial, which I'm happy to say that today I got reports that patients are being injected with our technologies, and they seem very happy and satisfied. So we're on the way to get a product approved next year with a lot of, sacrifice and support from the different parties here in the state mainly, and the university being second to none in that. I think that if I just recap the experience is that the university is willing and really embracing this philosophy that it is a center of innovation, and that this is enabling economic development and growth, and that through licenses and a little bit of risk sharing, we're able to make very big things happen. Today we have 13 employees scattered across the states in Europe, and we just hope to make that number keep growing and to being something positive to spread the word that the innovations that happen in the laboratory shouldn't end at a publication. They can spur passions and dreams come true, and potentially big corporations happening out of here in Columbia, Missouri, or the state as well.
Okay. So, Louise, you talked a little bit about investment. So I know, for example, the Missouri Technology Corporation has placed some investment. The university has placed some investment through the Enterprise Investment Program of a few years ago. And I know you have been before many investors, giving many pitches. And I think you even have some later today, right?
Yeah, a few minutes.
A few minutes, so we're going to be sensitive to your time. But in those discussions, can you talk about what the investors want to know about IP and some of the drilling that you receive from them about IP? And then I think we all know the answer to that, but would they have put the investment up if you didn't have the IP?
Yeah, I mean, it's a great question, and I'm going to jump a little bit to business law, and pardon me for my mistakes here, but in the presence of attorneys. But when the most traditional type of investment, if you would so call it, is what a bank would do as a loan. And when you have a startup and the bank, is considering your investment worthiness, they say, what kind of collateral do you have? And, in terms of collateral, how do you secure that? If you bought a house, you know that. And they value a company on the merit of the IP. That's your collateral. So that talks about the value of the company. Is really, at that point, there's no really tangibles, not equipment. The intellectual property of the management is kind of second to what the intellectual property position of the company is. And so it's fundamental. It's an enabler. And the mindset of, if you have something valuable, make an invention disclosure should not be in question. I mean, it's a way to ensure that there's fruits from your work. And so when I'm talking to investors, that's something we cannot oversee. It's just where our intellectual property position is. And, I mean, we were really aggressive because currently our intellectual property is still being pursued in parallel. It's something that you also should take as a note that the process is very long, 3 to 5 years to get a patent. And so generally, what I would say, you don't have to wait till the patent is issued. You look at what indicators you have for the patent to be issued. One is a very robust literature review. That is something you can present to investors, or patentability review from attorneys that are trustworthy, or in initial stages of PCT applications, patent collaboration treaty, they give you an international preliminary patentability report, which is a first opportunity to argue any novelty or patentability issues. And if you get a positive one from that, that's a short hanging fruit that you can present to investors. So to make the long story short, it is fundamental and is definitely an enabler. And if we don't have any IP, essentially a biotech company cannot exist.
Right. You talked a little bit about your journey as an entrepreneur and so forth. Could you share a little bit about the challenges that once you just have the IP, there is a long road ahead of that, and maybe talk a little bit about that? I know you're in clinical trials and continually raising funds and some of those challenges.
Yeah. So when I was talking to Steve about this speech, he said, talk about the good, the bad, and the ugly. But, I mean, it's nothing that people cannot imagine. It's very high stress. So you have to have a very good support network. Family is one. And I always highlight, investing in family as well. But, one thing that I happened to do yesterday as well, it just happens every time I have a university, and then I have to wait till the wife falls asleep and then continue working till midnight. But it's going to be a lot of work. 9 out of 10 companies fail. And the number one reason for that is running out of funds. So you can see where a lot of the allocation every time has to go to as a top management of a company. Doesn't mean that as an inventor you cannot partner with someone to do that, like, for example, myself or a business person, to try to do the fundraising. But it has been a challenging journey. There's been a significant amount of risk. I always talk about, from a chemical engineering background, that you have to do calculated risk so you can understand at a high level what kind of probabilities of success you have. Have to be able to endure those long nights of work and trying to be the best in everything that you do in regards to the company, because fate is out there to try to make it fail. It's just the probabilities of it. There's nothing that wants you to succeed. You just have to overcome all odds to make it succeed. That's just kind of the tendency of entrepreneurship and in general, everything that encompasses a startup.
Hey, Steve, I'm wondering if Louise could comment a little bit on Sheila's role and how she works inside of this as a faculty member. She couldn't be with us today to speak with you, Louise, so maybe you could speak for her and give us a little perspective on that, since so many people are also faculty members. investors.
Most definitely. Dr. Sheila Grant and Dave Grant, definitely have been enablers for this. When we stood in front of investors to say, there's this great technology, there's this great potential, and I haven't spent 1 year in research. They looked behind me, and they were, behind us, to back us up, and to say, we're standing behind this. Our name and our research is here. We've entrusted this management team to make it move forward, and thereby, when you invest in them, you're investing in us. And it's a partnership. They were founders in the company, and they very much have that stake of ensuring that it succeeds. And I think from day one, the mentorship relationship has always been there. A problem the company has is a problem that they have. They've gone way and above their abilities to try to support in time and expertise and networking for us. And a lot of times that meant meeting in the lab Saturdays and Sundays. A lot of times that meant asking favors of colleagues to collaborate with us for that. I think, she's written, I forget the term, professional declarations for IP defense. I think about 6 of them, which takes a lot of time from our day job to try to, argue that intellectual property is novel. And so the support is there and continual. And I don't think you can really have a success story without the support of the inventor and mentoring relationship with if it's a young management team with the management team to be able to make it happen.
I know Sheila's not here, but having talked with her, and I know you've had probably many conversations, why didn't Sheila just do this herself, her and Dave?
Yeah, and I think that's where I just commend her and Dave Grant and their humility. She said, I have 15 years of research in the lab, and that's what I love to do. And I want to continue doing that. And I feel out of place trying to negotiate contracts or really trying to put together a business plan. We need the additional expertise. And that's where that collaborative, complementary approach came out. And I think if she was here, she would just say, I just realized there's shortcomings in my experience. I'm very good at some things, and some things I'm not. And I'd rather share the pie than to let it shrink and collect dust on a shelf.
So, any last remarks or anything that you would like to share, or maybe even sharing anything that have been some of the challenges with IP?
Well, I think it's important to highlight the process of negotiating the IP out and some, good practice that I believe would be good. And we have the Office of Technology Transfer here to correct me if I... But the one thing I'd say is what I see over there, I see supporters of our technology. That's the universities, at least my personal experience. They want to see this succeed. They're vested into it. They're supporting it. And, the intellectual property is an asset that they have to try to protect and nurture. And in that sense, getting it out is not going to be easy, even if you're the inventor. Because for the patent, when I was negotiating it out as a student, I had the backup of all the inventors. They wanted it out. So it's going to be difficult, and that is part of the selection process. You don't want to make it so easy that people just not license it out and let it sit somewhere and see what happens. Good practices are when you have an invention in an early stage, recognize it's valuable. I would say sign an invention disclosure. Get a preliminary patent in. That will give you 12 months to continue to polish and improve the technology. The proof of concept has to already be there, but not all the research. And in that 12-month process, you're thinking, well, this is hard work, and I've disclosed to the university. I'm not yet in the position to license it, but there's something called the exclusive license to option, exclusive option to license, which essentially means you have agreed with the university to negotiate a license within a certain time frame. So you can be sure that you can be involved in the commercialization of it, if that's your intention for the technology. Hopefully I'm not saying too much, but I think, that's a way to enable you in the mindset. So exclusive option to license is a good way to kind of start continuing to develop the technology. You know that you will be part of that commercialization or have the opportunity to later negotiate it out. And then there's another thing, that when the university licenses to an entity, they're looking at that entity for the source of commercialization. So as an inventor, the role doesn't really become short to just saying, I'm going to market the technology to get a licensing deal to a big company. No, it means that you have to develop, have the plans and the architecture and infrastructure to move it forward in development. So that's something to realize, is that they don't want to just license it for you to turn around and license to someone else, because the license deal is not going to look very good in that respect. It is the plan to move it forward, to look for partnerships, for investments that will allow you to really get through the hurdles and the reward, that is expected. So as a summary, I would just say that the university is very supportive. There are strategies and techniques to make it a win-win. That's how I always see any negotiation. And that, founders, inventors have a lot in stake and a lot to win from this collaborative relationship. And, it was mentioned that this university shares one-third, one-third, one-third. I don't know if that everybody realizes. I mean, that's one-third of royalties of that intellectual property that will go straight to the inventor, which is a significant amount of incentive. If you're not an expert in commercialization, get it into their hands. They will try to commercialize it, and you have made your investment in itself. If they succeed, you will succeed as well.
I think, Hank, you have one more question?
Well, yeah, I was going to say one thing. That was such a great summary, but, is this company and its product, is this where Sheila and David thought they were going to start? I'm pretty sure it's not, right? So maybe you can talk a little bit about the evolution of the technology and how that took place, just to sum up, so people understand that.
A lot of times, investors, they see, a lot of times they invest, the IP position is very important, but the management. And because they realize that there's going to be things that are known that you have to do a pivot, the famous pivot in startups. So you have to not be so married to your mission and your direction that you can recognize opportunities that are lower-hanging fruit and adapt to them. And so initially, the research from the Sheila grant was not for aesthetic medicine, which we are currently commercializing due to economic and investment reasons. We are commercializing something that will replenish lost tissue, so it's scars, acne, but wrinkles is a big part of the market. And so we can get to the market very fast. But they were researching how to make coatings on sensors based on nanotechnology, and it wasn't working. It's collagen-based coatings for sensors, and that took a lot of years of research. But then with the biodesign program, they recognized this could be a great soft tissue augmentation filler. And so they were amenable to that and, looked at what is, I think, a pragmatic approach for that. So that's step one. And your research can turn into a solution for something you don't anticipate or particularly love or know about. Because Sheila didn't know about dermal fillers. She'd say, "What is that?" Dr. Grant. The second pivot is, the technology aspect of it. So we are commercializing nanotechnology, nanoparticles. And from a researcher standpoint, it's like, we've been doing research for years. Of course it's safe. We know about this. And you start looking at the industry, and there's like a pipeline, Dr. Cannon is here as part of products that are yet to be approved with nanotechnology, that are still, it's so cutting edge that the FDA still hasn't given green lights and a lot of that. So we, with our limited resources, cannot fight that fight very well. So we did a pivot as well and incorporated a simpler technology in to launch before it, while we continue to, in parallel, develop the nanotechnology part. And it seems that has been a win strategy because, like I said, we are in clinical trials right now, and we're looking at an approval at the beginning of next year.
Luis and Steve, I want to thank you both very, very much for that presentation. That was terrific. I think Luis covered about 12 different things that we need to talk about now, from invention disclosures to PCTs, and I know we have the right people to do that. I'd like to turn the podium over now for the legal perspective to get that started to Dean Myers and to his colleagues. So, Gary, it's all yours.
Thank you, Hank. And in particular, I want to thank you, Hank, for recognizing the importance of intellectual property for the university and for putting on this event. I hope it will be helpful to you. At its core, intellectual property is an area of law that protects and rewards innovation and creativity in any field of endeavor. And it's something that's relevant to faculty members, for example, whether you're in the humanities, journalism, science, or what have you, because it can cut across all fields of endeavor. And I want to give you just a couple very quick examples before turning the panel over to our two law faculty members. Let's say you're starting a yoga studio in downtown Columbia. That's going to present trademark issues about what brand you use in the marketplace. Copyright law plays a critical role in protecting any kind of creative endeavor, whether it be software, media content, or what have you. And of course, patent law, which is the main area of our focus, protects all kinds of innovation, biotechnology, medical devices, new drugs, and so forth. And so all of these areas of law are critical both to small businesses and large, and to academic institutions and faculty members in all fields. Now, I'm very proud to introduce to you today two of our law faculty members. Dennis Crouch is a Princeton-educated mechanical engineer who received his law degree from the University of Chicago, practiced in that city, and then joined our faculty. He's also very well known for being the operator of the Patently O blog, which many patent lawyers in this country use as their startup when they turn on their computer every day. Our second faculty member, Erica Lietzen, is a graduate of UCLA and the University of North Carolina, and received her law degree at Duke. She was a practicing lawyer in Washington, D.C. with a large law firm before joining our faculty this year. The two of them are core members of our new center, which focuses on intellectual property and entrepreneurship. And I'm very pleased to turn the podium over first to Dennis. Thank you.
Great. Thanks so much for hosting this event. I think it's a great topic. You'll notice when you listen to Luis talking that although he's not a lawyer, he's a business leader, he's already extremely well versed in intellectual property issues. And in every technology-focused startup that I have seen that's been a success, the leaders really do get to know the intellectual property and certainly don't just leave decisions up to the lawyers. Just because there are a tremendous amount of strategic decisions that have to be made on a regular basis, and although lawyers are very good at providing options, they may not know the core business and the focus and understand where the pivot is going next. And so I would commend to you to think more about this area. Now, I want to take a little step back kind of as a law professor and just talk a little bit about what intellectual property is generally. I teach a class called property, and when we talk about property, property really is this notion of the right to control some resource. Usually that resource is something tangible like a bit of land or perhaps your car. With intellectual property, we're talking about intangible resources and particularly creations of the mind. Now, that's a great thing for a university to talk about because that's the kind of things that we do here at a university. Now, generally, right, we've got this big umbrella of intellectual property law, but if you look through our statutes and our cases, there's actually no such thing as intellectual property law. Rather, what we have is a bunch of what I call doctrinal silos, right? We've got these separate areas that are separate and distinct. Here I've got some here, patent law, copyright law, trademark law, trade secret law, and in fact, depending on how you define it, there are several others. One area that I think of as important is that of design rights as well. Now, the Supreme Court has also repeatedly held that there's some amount of interstitial space, right? And you see that these aren't covering the whole areas, but there's some space, right? Some things we can do, and what the Supreme Court has said that there are some ideas that are kind of the building blocks for research, for technology, for life, and those building blocks are things that can't be protected. And part of that comes through with I'm sure what you've heard of the fair use doctrine that comes out in copyright and trademark law, but it comes through in other areas as well. Now, intellectual property law in this country is very old. It stems from our Constitution, so we're talking about 1789. 1789. The first Copyright and Patent Acts were passed in 1790 and 1791, so that's before the Bill of Rights. And so these go back a long ways. And throughout this whole time, we've had continuous battles between folks wanting more rights and folks wanting less rights. And so we've had an ebb and flow in terms of what things are protected. Right now, we've got a lot of battles going on. We've got questions of if you've got social networking technology, or maybe you've got genetic testing equipment, or some kind of data manipulation software. Right now, all of those are questionable in terms of whether or not they're patent eligible. And the Supreme Court is addressing those even in the next year or so. Another big question for copyright is something like, are computer APIs copyright eligible, for those of you who are software engineers? For trademark law, we often, we're asking repeatedly, to what extent can customers control the reputation of someone else's mark? And we see that now with online reviews all over, and kind of the world is changing in that area. With trade secret law, we have lots of disputes over elements of former employees. For instance, how long can a company force its former employee to keep the company's secrets, right? Does that last for the rest of that person's life and even beyond? Or is there some timeline where we can cut that off, right? All those are kind of ongoing questions. Now, it turns out for basically, almost every product that you see, the company tries to think about these different areas of intellectual property and layer them, to find a layered approach where you might have some product where the design of it and maybe the software embedded in it are protected by patent law. You may have some set of instructions and also the software, if there's some software, maybe some kind of graphical design or musical interface, all protected with copyright law. Obviously, your logo or perhaps your business name or product name would be protected with trademark law. And then at the same time, you may well have some trade secrets, and you likely do. For instance, the exact process of manufacture, and certainly lots of business information like your customer list, the exact price you're paying for different things, and how much it costs you to manufacture, which is often important to keep that secret as you're negotiating the sales price and your profit margin. Now, the hope with all this intellectual property is that is the kind of the policy background. The idea here is this is going to help facilitate transactions. You've got something to buy and sell, facilitate innovation, and the hope is it doesn't hinder further progress. Now, just as I wanted to pause for a second and think practically. For those of you, many folks kind of start down this road without kind of direct legal advice. You don't have a lawyer, you don't have a patent attorney, and you're thinking about what to do. Now, it turns out, there's a couple of key points, and one of them Steve alluded to, this notion with patent law, as well as trade secret law, if you publicly disclose your information prior to filing your patent application, you have this strong likelihood that you've given up your rights. And that's certainly in tension with the university mission, but it's something that you have to deal with, and it's something that the law says is true. And so that's kind of a big element that you have to keep in mind. And the last kind of practical point I want to just mention is with regard to ownership. The usual rule of law in this country is that whoever does the creative work, that is the invention or the authorship, is the one that owns the intellectual property right. However, that right is a property right in that it can be transferred. The usual requirement is that the only way to really transfer it is through a written agreement, and oral agreements aren't sufficient. But there's also a rule that or there's also an approach that most employers, including here University of Missouri, have an agreement with their employees that there will be a transfer of rights. Although, as the university does, we treat it differently depending on if it's a patent or copyright and the type of copyright at stake. And so that transfer can go to the university or whoever your employee is, depending upon what it says in your employment agreement. Of course, we've got the experts on how our system works who are going to come up later in the program. Thank you. I guess Professor Litzen will come up next and extend this out with some extra patent topics.
right, thank you very much. I am going to provide a few observations on the role of intellectual property with respect to new drugs and biological medicines. What am I pointing at?
Is the arrow still going backwards?
But what do I need to point at to do it?
To make it work?
Yeah, oh, over there.
Yeah.
Okay. All right, so I'm going to start with the basic observation that we have as a society a profound interest in the development of new medicines. There are, and I'm not telling anybody here anything you don't already know, there are some really terrible and intractable diseases that we still need to do a lot of work to develop new cures for. I'm thinking things like ALS, for example, and Alzheimer's. There's a lot of work to be done as well on those. On cancer, we have several decades worth of work in the battle against cancer, and we've made great strides with respect to some, but there are some as to which we have barely budged the needle. We have looming ahead of us at this point a real potential catastrophe with respect to antibiotics, antibiotic resistance, and the availability of treatment for resistant disease. And for that matter, as you know, we are really in a race with respect to antivirals and vaccines for a lot of the newer and more devastating diseases. And so, and actually, for that matter, as the U.S. population ages, we are going to have enormous pressure on the medical system for treatments, for effective treatments to manage the ordinary diseases of aging. And so we have now, perhaps more than ever in our history, a really profound need for new and better medicines. The first point that I really want to make, my first point today, is that domestic intellectual property policy is a critical part of the solution to that, perhaps the key to the solution. And so my first point is we as a society and the government, public policy makers, use a variety of intellectual property incentives, and I will talk about intellectual property-like incentives, in order to stimulate research and development into new medicines. And this is really for two reasons. Because we recognize collectively this profound need facing our society, and because there is at this point a lot of very good empirical research suggesting that intellectual property incentives work. Dennis talked a little bit about the traditional tools of intellectual property, all right? And I in my head, I put trade secrets as a less traditional tool. So when I think of traditional tools, I'm thinking patents, trademarks, and copyright. Trademarks and copyright have a role to play with respect to new medicines, but it is a minor role. There are trademarks for the brand name for the product, and copyright may play a role with respect to certain publications, but it's really patent law of the traditional tools that is the engine, that is the key of the traditional intellectual property rights. And in the world of medicine, and I mean chemical drugs as well as biological drugs, we could be talking about a patent on the basic substance. We could be talking about a patent on the finished product that is given to patients. We could be talking about a patent on the formulation that has been invented that makes it safe and effective. We could be talking about a patent on the way it's made, the method of manufacturing, or for that matter, it could be a patent on a method of using it, or even something sort of earlier in the process, a method of isolating a particular substance, or a method of testing for specifications. In this new drug, biologic, medicine space, patents can be specific to one medicine, or they could be general, common to many. And if the discovery that gave rise to a patent is valuable, that patent itself can be enormously powerful and valuable to the inventor and to anyone to whom it is licensed. Sometimes, however, through no fault of the inventor, a patent may not be available. And yet, the medicine is enormously important. And we may have a real serious need for the resulting medicine. There are what I can think of as less traditional intellectual property tools that are also available, and particularly where patents fall short for one reason or another, these less traditional tools can play a really important role. The first one that I think of is what we call exclusivity, which is something administered by the Food and Drug Administration, and it is essentially a period of time with respect to a new medicine before copies can be brought to market, a period of time after approval before copies can be marketed. And it can be 3 years, it can be 5 years, it can be 12 years. It depends on the drug, it depends on how much research you did, it depends on what came before. But that is an intellectual property-like incentive for new medicines. It can be weaker than a patent in some cases. It can be stronger than a patent in some cases. But it is different. It's a completely different thing. And like a patent, powerful, valuable. Another one is trade secret law, which Dennis had on his slide. I think of it as a slightly less traditional intellectual property right in this space. It is the protection for a secret. It is what Coca-Cola relies on for their formula, which is in a vault in Atlanta. And it is often used for manufacturing know-how, how something is actually made. But that's just the start. The next thing, and what I think is the wave of the future, is tailored incentives. So, what do I mean by a tailored incentive? I mean an intellectual property-like right that is specific to one particular field of research. And so, for example, back in the 1980s, Congress passed a statute that provides special intellectual property-like incentives for medicines for rare diseases. So if you have a product that treats a disease for fewer than 200,000 Americans, there are special incentives for you, partly tax benefits, but also a special exclusivity, a special protection against copies, and in fact against other innovators. We also have, and that's been enormously successful. There are also special intellectual property-like incentives for pediatric research, which wasn't historically done, partly because you needed to have special formulations for kids, partly because there wasn't really any market need for special labeling because doctors would just extrapolate based on weight. So there wasn't really an incentive to do the research. Now, there's an extra 6 months. Oh, that was exciting. No, it's okay. Now there is an additional 6 months of exclusive marketing for pediatric research, also very, very successful. We now have a special exclusivity incentive for antibiotic research. It remains to be seen whether that's going to solve the problem. I think probably not. It's a start. But this is, I think, the wave of the future. And in Congress, on the Hill, there is discussion of special incentives for pharmacogenomic research, for geriatric studies, for tropical diseases, and for the diseases of aging. So I think that is in part where we're going. Bottom line to this first point is, based on the empirical research showing that, in fact, incentives work, we have now a pretty complex overlapping web of intellectual property incentives and IP-like incentives that are designed to generate this research that we so desperately need. What that means is if you are working in this space or working in a space that will become this space, you need to educate yourself about the IP rights, but that's not enough. My second point, about which I will spend less time, but I think it is equally, if not more important, is that this intellectual property law and policy ultimately is intertwined deeply with the federal regulatory law and policy that governs new medicines. And by that I mean the rules that relate to research, development, and access to the market. They are intertwined, and I would say they are intertwined in at least 3 ways. First of all, the non-traditional tools that I was talking about, the exclusivity, for example, is administered by FDA. And FDA is influenced by laws and policies and considerations that are very different from the ones that influence the USPTO. It is a different culture, and those incentives are administered by that agency with that culture. Second, the two systems operate in tandem from the very beginning. As soon as you isolate a substance in the laboratory and you're thinking about a patent, you should be thinking about the FDA regulatory process as well, because perhaps what you write in the patent will be similar to, hopefully not inconsistent with, what you say to FDA about the very same invention. They operate in tandem. And the third way in which they are intertwined is that hopefully once the intellectual property has been understood and the opportunities have been reached, there will be opportunities to enter into strategic partnerships that will be governed and that will operate within both frameworks. And the documents that govern whatever partnerships and arrangements you have will probably reference both IP ideas and milestones and regulatory IP and milestones. And they are happening at the same time, and they're related to each other. My last point. In addition to the profound public interest that we have in new medicines, there is also a profound public interest in affordable access to those medicines, okay? And timely affordable access. That has at least three consequences to think about which relate to IP. The first is that our domestic IP policy reflects a careful balancing of enough incentives to innovate and soon timely access to affordable medicines. That goes to things like how quickly they can be copied. There is a careful balancing and attention at all times. Second, as an intellectual property owner, you will face enormous pressure to ensure that products are affordable in a timely manner. This is just a fact of life in this space. And dealing with that requires careful thought and sensitivity. It is an important policy issue for all of us. And third of all, which will lead me to my final slide, this is an area where reasonable people disagree all the time. How soon there should be copies, how long this exclusivity should be, whether we should let people break it and cut in line, and so forth. It is an area where there is constant discussion on the Hill. The policies and the balance are always under scrutiny. And that means, as a practical matter, although IP plays an enormous role here, driving and rewarding innovation, the laws and policies are going to evolve, and I think that they will change meaningfully over the course of our collective professional lives. And as a result, this area, IP and regulatory IP with respect to new medicines, is an area in which it is vitally important to stay engaged and to stay alert. Thank you.
We're about to move on, but just before we move on, I'm wondering if one of you could just cover the original intent of the Constitution as it relates to IP and the idea that we're teaching documents, and then maybe Erica or Gary could just cover the issue of claims, breadth, and quality. And how that affects a patent.
Yeah, so, thanks, Ed. So, and I'll just speak. Right, so in the Constitution, there is what we call the intellectual property clause, and that's actually the one clause that's there that's really focused on purpose, whereas other clauses give certain powers to Congress. They don't really say why. But the intellectual property clause does introduce the idea of offering patents and copyrights to inventors and authors in order to encourage advancement in those fields, right? And so it is this basic economic interest that we want to offer these rights with the hope that it encourages the next person to say, hey, I can get something out of this too. Now, from a policy perspective, this is extremely attractive for policymakers because they essentially spend no tax money on intellectual property rights. Rather, all they do is give out a property right, but there's no tax money spent there. Many of us have received government grants, and many of us work at a state institution that's partially funded by taxpayer resources, and so there's a constant fight, a battle over getting that money, and you can see the attractiveness for expanding IP rights in that government doesn't have to spend any money to do that. Oh wait, and then what was it?
Well, I was also, that's great, thank you. Just very briefly about claims and the drafting of claims and how important that is to,
Yeah.
to the quality of the patent.
Yeah, so with a patent, someone drafting a patent lays out what we might call the metes and bounds of your legal right in something called a patent claim, and that really focuses in on what your invention is in terms of your legal right. What can you control? And the general idea is that you would like this to be as broad as possible so that you can exclude more potential competitors. But on the flip side, about half of patents that are attempted to be enforced are found invalid because the drafters of the patent made the scope too broad. And so there is an interplay there between how broad you can go, both by what the Patent Office will allow and what a court might allow in the future. One approach that many folks take and the Patent Office allows is that you actually restate your invention in many different ways. On average, people draft about 20 claims in a patent, each one of them kind of separately, using different words and maybe a different focus, explain their invention. And so then that really kind of strengthens your rights because each of those is a separate right in parallel.
I think I'm anticipating some of the discussion that's coming later, so I won't go further than that. But I will ask Erica one question, and that is, with respect to incentives that you talked about, how do you see those playing out for universities and university researchers as opposed to, let's say, pharmaceutical companies and the like? Do you see a role there?
Well, I think, yeah, I do. I think at the end of the day, any product that is, or any invention that is ultimately going to lead to a new medicine, all of the conversations and collaborations and licenses that may be negotiated, for example, by the university, happen within the framework of the eventual rights that product is going to have. And so understanding how robust that protection is going to be, I think affects, to be sort of frank, it affects your negotiating leverage.
Good. Thank you very much. Joan, I'm sorry I cut you off there, but I wanted to just ask some quick questions. Now I'm happy to introduce Dean Joan Gable, who will talk to us about business perspective.
Thank you, everybody. Thank you, Hank, for having all of us here and for facilitating this, and to all of my colleagues. I want to loop back on a couple of things that you've heard so far. I sort of view my role today as taking the incredible intellectual capital that you have in my law school colleagues and then translating it into why you care about what they've had to say and why this should in any way alter the typical things that we do that Steve was describing as researchers and scholars into the commercialization space, and then access these tremendous resources that you're going to hear from in a minute that we have on this campus and in this system that help make all of that happen. And the example I'll use to start that conversation is my former student, Luis, who I met in that first semester. And so much has happened since then. You know, he had a baby, and all this while he was doing this work as a student and now as a professional. He met Sheila Grant through a class in the MBA program. And we have a variety of ways in which this happens, a lot of which will happen in all likelihood through some association with our incubator. And my colleague Bill is here, who will explain to you exactly how that works. And I tell you that not to stump for the MBA program, although of course I'm stumping for the MBA program, but also to let you know that there's a lot that happens when you switch what you normally do as a scholar and a researcher and a scientist or whatever you consider yourself to be, new idea generator, into a commercializer. There's a lot of intellectual capital that can seem very overwhelming and intimidating, but the fact is there are also a lot of resources, and that's one of the things that is unique about engaging in this type of activity in a university environment, is we have a lot here to help you. And so the expertise that Luis has now, when he talks about very nuanced strategies that he's used in taking an idea that he discussed as an MBA student in his first semester all the way through to where he is now with millions of dollars of funding and employees, that happened in a very long, steady process. He didn't come in the door knowing any of that, and neither would any of you, and neither does any of us. You know, we've all learned our areas. And so what intellectual property is one of the portfolio of tools that, as an idea generator who may eventually take that idea to the marketplace, you want to leverage and take advantage of. It's all part of a spread of things that you need in order for things to go from idea to business, if you want to think of it that way. And we have rock stars as IP scholars and rock stars as IP practitioners all sitting here who can share their expertise with you, and you've already heard from a lot of them. And it's a village process. It's a village process for serial entrepreneurs too, which Bill can tell you all about. You know, this is something that is a profound thing to do, to take something that you just think of and bring it to the marketplace. I mean, think about that. That's pretty amazing. And anybody who's done it, and we have somebody who's done it very successfully several times right here, will tell you it's always a huge team. And one of the fantastic things about being in a university environment is the depth of the team. And this particular university, thanks to Hank and Steve and everyone you see, that whole team, generously, that a lot of people in this sort of environment, our colleagues at other schools, don't have either the depth of resources or the type of shared ownership that this university offers. So you all, I'm assuming, are in the business of idea generation, new knowledge creation in a variety of ways, scientific ways, other ways. We study new ideas, new methods of business. I see colleagues from all over the campus as I look around the room. And all of those things have the potential to be commercialized, and all of those new ideas have the potential for some type of intellectual property protection, the portfolio of which was described to you by Gary and Dennis and Erica. And intellectual property law, in case it seemed technical and overwhelming, it is. It is, I would say, the most specialized area of law. It's a separate bar exam you have to pass in order to do it. They're all scientists and lawyers. Imagine that for a second. And this is hard. This is a very hard area of law. There's a reason why there is so much expertise that goes into being able to even offer legal advice in this area or claim any sort of expertise. If it seemed confusing which one you need, why a patent here, what's the difference between it? It is for us. So the idea of understanding which type of intellectual property you need as a prerequisite to being able to commercialize your idea is a fallacy. There are experts for that, and we have them here on a variety of levels. So just understanding that your new idea is commercializable is then something that you would sit down with an expert to figure out which type of intellectual property protection, how to take advantage of those incentives that were described to you. No one who generates ideas would expect to know how to do that. Even serial entrepreneurs don't know how to do that. They may know more of the vocabulary, I think, as they go through the process, but the technical process, the skill set, is best left to experts, and we have them here, fortunately. It allows you, though, to do things that you otherwise wouldn't be able to do. I think that's the core message that you should be getting from hearing from intellectual property experts and hearing from the people who would actually implement on your behalf if you decide to go in this direction, and I certainly hope that you do. It's a very unique space where you, as an idea generator, can actually, in the legal sense of that word, own that idea. And so we think of what's in our own heads. Of course, it's ours. It's in our head. But what does it mean to actually own it? In the eyes of the law, means that you can use it as property in the way that Dennis was describing. And that's a really cool thing when you think about what that means in terms of translating it into a potentially commercializable activity. So I think it was Gary or Dennis who referred to owning your car. And this is an example that I have used many times, and I don't mean to insult anyone's intelligence. There's a lot of very well-educated people in this room. But just as a way to think about this, if you own your car, what that allows you to do, it means you can drive it. It means you can let anyone you want drive it for free, or you can charge them. You can become an Uber employee. Maybe we'll get that someday. And do we have it in Columbia yet? I don't know. Anyway, we will eventually, right? You can take guests in the car with you for free. You can charge them. There are all kinds of things you can do with your car if you own it that you can't do just because you think of a car in your head. And that's the difference between an idea that is in your head and an idea that you own. And intellectual property is the tool to do that, and it's a necessary tool because it's the tool that, as you've heard from previous speakers, protects your risk. And ultimately, taking something out into the marketplace is risky. And that's really where intellectual property and business intersect. The strategy of business, the idea of whether you'd want to go there or not. So I look at law as a lawyer who has spent the bulk of her career in business school. I have this very luxurious ivory tower point of view about law. And so bear with me, and I know all my lawyer colleagues, and there's a lot of us here today, are going to roll their eyes at me, but everyone else, just bear with me for a second. That if you think about law in two different ways, you have sides of law that constrain you, the lie, cheat, and steal, things you can't do. And we think about law a lot as like a no, no, no type of thing, and it is. You have to follow it, you have to do that, and sometimes the law tells you no. But there's this whole underappreciated aspect of law that you've heard about that facilitates you, that protects you, that enables your strategy, and that's what intellectual property law does. You don't have to apply for any of the intellectual property protections or incentives that you've heard. None of them are required. There's no intellectual property prison if you don't do it. They're available to you. And if you access them, if you choose to access them, then you protect yourself from risk. And that's ultimately at the core of a business strategy. So when Steve says, would you put your research up and expect that no one would touch it, that it would be yours, that's essentially what intellectual property protection does for your idea, to the extent you'd want to make a business of it, that you would want to commercialize it, is it allows you to discuss it, it allows you to find investors, it allows you to take risks from competitors if you take care of it properly. And those are business strategies. That's what Luis and his team, as students in the MBA program in the incubator and now as the CEO of the company, have done for Sheila. That's how they've been partners in that process. So as an idea creator, you want to think about why you would care about what they've said. You care because it makes it yours. And if you do it here at the university, it makes it ours, and in a very generous, shared way that allows us to fulfill our mission of economic development. It allows you as an idea generator to really think about your ideas in a different way. I really think of commercialization as a type of intellectual pursuit. I know that's easy for me to say as the dean of the business school. I recognize my bias. But as scientists and scholars in the room, I really encourage you to think about, as you go through the cycles of idea generation and innovation in your research areas, how to invigorate that research, how to have the maximized potential impact of that research, what it really means to take that research all the way through on an arc into the marketplace for the ideas that are relevant for that type of pursuit. And then realize that we have all of the resources here that you would need in order to decide whether that's feasible, and if it is, in order to make it happen. And intellectual property protection sits at the core of that. So I think the lesson that you would want to get from a seminar like this, and from the specifics that you're going to get from our colleagues who work in the economic development side and the legal side for you as employees of the campus, is that when you come up with new ideas, to the extent that they would be potentially commercializable, it's not a painful thing to determine. It's not something that would prevent you from staying on track with your research. It's not something that would make you have to understand everything that Luis now understands as someone who has taken this into a commercialized space. It's something that you want to engage in early and with some understanding, and then turn over to people who actually know what they're doing. So with that said, thank you very much.
Thank you very much, Joan. That's a perfect segue into sort of the nuts and bolts sessions that we're going to have now that deal with how we sort of do intellectual property at the university as employees of the university, what it means, and we're going to start off with Scott Ullman from my office and assistant to talk about policies on patent plant varieties and copyrights.
Thank you, Hank. So we're halfway through the program. I hope all your caffeine levels are sufficiently high. This is the part where we talk about university policies. I'm not an attorney, but I did consult with one before as I was putting this together, and as always, disclaimer resulted. So this presentation contains an overview of the collective rules. The information is provided for informational purposes only, and of course the collective rules supersede anything I say here. So with that said, we'll move on. The specific policies I'm going to be talking about today are the patent and plant variety policy and the copyright policy. They're found in the collective rules in Chapter 100, patent and plant variety regulations 100.020 and copyright 100.030. I'll start first with the patent regulations. These regulations form a part of the employment contract. They constitute a condition of employment, and they apply to all inventions and plant varieties made during the employment with the university. So who's considered an employee under the patent policy? Policy says that any person receiving compensation from university services, regardless of whether they're full-time or part-time, is an employee, as well as any person being paid through monies handed to the university and then distributed to the person is also an employee. And then also any person who's voluntarily elected to enter into a written agreement with the university in exchange for being treated as an employee under the policy. And yes, we have had people ask if they could do that. So what are the rights of the university and its employees? The university owns inventions developed within the course of the employee service to the university. Each employee is required to assign the invention to the university that's made within the general scope of his or her duties. And I'll talk briefly about that in just a second. Each employee has a right to share in revenues that the university receives through the exploitation of that invention or plant variety. The employee owns any invention made outside the scope of their duties. So, for example, if a faculty member is working with an outside company over the summer, then as long as that invention didn't result from information or research that was done at the university, then that employee would own it, at least subject to any contract with the company. And then, though the university may own an invention, it may elect to waive or assign rights back to the inventor if it decides not to move forward with the invention. So I mentioned scope of duties. An invention or plant variety is made within the general scope of duties whenever the employee's duties included research or investigation and the invention or plant variety arose in the course of such research and investigation and is relevant to the general field of inquiry to which the employee was assigned, or whenever the invention or plant variety was in a substantial degree made with university resources. And that's through the use of university facilities, university time, or information learned from the university. So I mentioned that the employee is able to share in revenues from their invention. Under the patent policy for patents, the inventors receive a third of the revenue off the top. Then the university recovers any unreimbursed patent expenses. Then the net revenues then are divided equally among the campus, the department from which the invention originated, and then the university or system. For plant varieties, it's a little different. The inventors or breeders receive 10% off the top. The university then recovers any associated expenses, and then the remainder is split between the breeding program and the university, with the breeding program receiving 95% of the net revenues and the university 5%. So I'll talk briefly about the copyright policy. In terms of ownership, the university owns any copyrighted materials that were commissioned for its use by the university, created by employees if the production of the materials were a specific responsibility of their position, or sponsored works, whether they were sponsored internally or externally. But this doesn't apply to grants to perform research where the production of the materials were ancillary to the purpose of the grant, and employees continue to own the copyright to scholarly and other publications. So faculty members still continue to own their data they publish, the articles, and so forth. Also, the university has an ownership in copyrighted materials that are created through substantial use of university resources, similar to the patent policy. If it's anticipated that substantial resources will be used, then the author and the university will will enter into a written agreement setting forth the terms of use of those materials and the revenues that are received, how those are distributed. So, software created by non-academic employees. So if, for example, a programmer in the IT department, software associated with these works are considered work for hire. Ownership belongs to the university, and that employee isn't deemed an author, and the ownership rights belong to the university, and they wouldn't be entitled to share in revenue as a faculty member or employee who wasn't hired for that specific duty. And as it says, it doesn't apply to employees whose primary appointment is academic, so faculty members. They continue to hold those works. So copyright revenue distribution. As I said, there's an agreement put in place between the authors and the university. The policy says that generally 50% of the net revenues will go to the department from which the work originated, and 50% will go to the authors or producers of the work. However, the university can enter into agreements with a different distribution based on the specific circumstances. So I provided just a brief overview of some of the key elements of the intellectual property policies. When applying the policies to a particular fact situation, keep in mind that each situation is unique and many factors have to be considered. So it's important that if you have any questions about the policies or how they're applied, that you speak with your tech transfer office to get clarification on those policies. With that, thank you.
Thank you very much. I appreciate it. For people in the audience, if they want a copy of what you just presented, would you be willing to,
Sure.
To email that?
Absolutely.
Or maybe we could get it to you and you email that to folks so they don't have to go hunting
Right.
for it. Okay. I'd like to move on now and pick up there with Craig David, who runs the Office of Sponsored Programs. And Craig's going to talk about identifying IP and navigating the contract process, and I think some of the new approaches we're taking to that. Right, Craig?
That's correct. I don't know if I'm just slightly taller than everybody else or that I shy away from the spotlight, and my staff will tell you that that's definitely not the case. Okay. All right, well, never in my wildest dreams when I looked at the agenda and the names in front of me did I expect that we're going to be on schedule. But we are on schedule, so that's a good thing. But also it's a little added pressure for me to keep it to 15 minutes. All right, so sponsor programs. What's our role as we talk about intellectual property? What's the role of sponsor programs in that process? Where do we get involved? How do we identify IP language? How do we protect our investigators? That's what I'm going to try to describe to you today. And if you look up here on this slide, the very first bullet point is very important. And I put that first because we really emphasize customer service as sponsored programs. And we see our main goal and objective. We want to facilitate the goals and objectives of our investigators, period. There's no question there's a significant amount of administrative burden, increases every year, compliance requirements, different hurdles for our investigators. So anything we can do to help navigate those hurdles, to help make things more efficient, that's our goal. At the same time, our office, we're delegated the authority to sign contracts and bind the curators of the University of Missouri. So if we're going to have an external contract with an external sponsor that goes to an academic unit, that's going to come through our office. So we're the responsible party to sign those contracts and negotiate on behalf of the university. And that's important And I want to go back to the first bullet point, is we're here to facilitate the goals and objectives. We want to help investigators get contracts in place. So the last thing we want to see is, an investigator goes and meets with a sponsor, comes back and says, I've got a deal in place. I'm going to do the scope of work for $20,000. And then we say, well, can we look at the budget? Did we include F&A? Oh, I forgot F&A. So that puts us in a tough spot. It puts the investigator in a tough spot. Is it fixable? Probably, but it's not the best approach. So just knowing that we have your best interest at heart, come to us early and often so we can help navigate the processes that we need to navigate. So we're concentrating on intellectual property language today, but when we look at an agreement, there's a variety of different clauses, a variety of different subjects that we review in a contract. And this list here isn't all-inclusive, but it just gives you an idea of the different types of things that we're looking for in a contract, whether it's from industry or anybody. Legal language. We're going to work with General Counsel's office to make sure that this contract is approved in legal form. Jurisdiction, if there's a dispute related from this contract, where are we going to handle that dispute? Is it going to be the courts of California? Is it going to be the courts of Missouri? It's important that we identify that up front. Indemnification. We see indemnification language really often. As a state entity, as a state institution, we're not allowed to hold harmless or indemnify the other party. So that's a very common clause that we have to address initially as well. Sovereign immunity. That means basically that we can't be sued in federal court. That's a really good thing to have. And General Counsel is really adamant that we don't waive our sovereign immunity. So we're looking for legal language that we have to identify up front. Export controls. Is the work we're doing, does it involve technology that's export control? Do we need to get Jennifer May's office involved? Do we need to change the language in the contract that relates to export controls? Conflict of interest. This is a big one. It's a scary sounding thing when you have a conflict of interest. Is that a bad thing? No, not necessarily. And as we encourage faculty startups, we're going to encounter much more conflicts of interest that we have to deal with. Conflicts aren't a bad thing. It's just something that we have to manage. And then we go back up to this first bullet point, the Conflict of Interest Office, COI Committee, our office, we really want to help facilitate and protect the investigator. And I haven't seen a conflict of interest that we haven't been able to manage through an oversight committee or some other mechanism. So even though that sounds bad, it's not. Restrictions on publication. We want to make sure that we can publish in certain situations. And then the more boring stuff, budgets, signatures. Do we have our chair's signature, dean's signature, all the co-I signatures? And again, this isn't an all-inclusive list, but these are the types of things that we look at. When it comes to IP, we traditionally spend a lot of time negotiating intellectual property language with industry sponsors. Why is that different? Why is that different than federal funding? And the answer there is in the next bullet point, the Bayh-Dole Act. The Bayh-Dole Act was a piece of legislation, I believe it was executed in 1980. Prior to 1980, any IP that's generated from federal funds, we had to assign that intellectual property to the federal government. And what the federal government figured out was they have all these patents, they have all this IP, and they really weren't very good at commercializing that intellectual property and getting it into the marketplace to benefit society. So in 1980, a piece of legislation, Bayh-Dole Act, was enacted, and what that allows us to do is any intellectual property that's generated from federal funding, we're allowed to own that IP. And so that's a significant piece of legislation. I think I was 11 years old. My parents didn't tell me. I'm still upset about that. I'm going to share that with my kids. They're going to hate me, but they're going to hear it. So what's changed? As Hank comes on and talks about IP and being smarter with IP choices, what changed? What is changing with relationships to sponsor programs? And the biggest change we want to make is we really want to empower the investigator to make decisions about IP when we're contracting with industry. The person that has the most knowledge of the scope of the work and the contract and whether or not IP is going to be generated, whether or not it needs to be protected, is the investigator. The investigator knows best. So historically, where we may have taken the initial position when we look at an industry contract that we want to own all intellectual property up front. That was our first stance. Now we're taking a step back. We say, all right, let's engage the investigator and ask them, is this something we need to protect? Because when we start negotiating intellectual property language with an industry sponsor, it can delay the execution of that contract for a long time. And usually with industry sponsors, they like to get contracts in place quickly. We like to get contracts in place quickly. And I really want to emphasize that we're empowering the investigators to make that decision. We're not transferring that responsibility to the investigators. We're not saying, you decide, good luck. We want to provide our investigators with the tools to make that informed decision. The expertise of OPMIR, the expertise of OSPA. We're going to have that discussion up front. And we definitely don't want to send the message that, hey, you need to waive your IP if you want to get this contract in place quickly. That's not the message that we want to send. And I've also heard across campus a few times ago, the new administration, they're giving away all our IP. They're encouraging us to give away our IP. Never heard anybody state that. The fact of the matter is, all we want to do is empower the investigator to be involved early in those decisions. All right, if we go back, we talked about all these different elements that we may have to negotiate in a contract, that we may have to review. Wouldn't life be wonderful if we didn't have to negotiate any of that stuff? If we had a standard agreement that everybody agreed to initially up front. That's one of our attempts when we partner with industry. We developed a short 2-page contract. I've seen a lot of industry contracts that get very lengthy, 30, 40 pages. We've condensed an agreement down to 2 pages that we feel is very industry friendly. And what it states up front is, we don't want to own the IP. You can have it, We don't expect to generate IP. PI doesn't want to protect the intellectual property. You can own it. And in addition to that, though, what we ask for is if we're going to waive IP up front, we get an extra 5% F&A. Our current F&A rate for research is 53.5%. So if it's a research contract, then we're looking at 58.5%. That's not a significant difference. And in reality, 58.5% doesn't cover our costs. When we do our F&A calculation and negotiate with the federal government, we believe our F&A rate's over 80%. But we negotiate 53.5%. So for industry to get a 58.5% F&A rate, that's not a bad rate. And it's definitely, I guarantee it's lower than most industry F&A rates. Another important part of this contract is we want to retain our publication rights. So if up front we can get with our investigator and decide we're going to partner with industry, intellectual property is not important, we have a simplified form that we can enter into. Also, I got a link here. This is our campus policy on intellectual property, and it really just states a lot of the things that I'm telling you today. There was a policy, business policy manual 203, BPM 203. And what BPM 203 said was that if we're going to partner with industry and we're going to waive our IP rights, we're going to have to recover 200% F&A. 200%. That's a barrier, right? That's a barrier. What industry wants to pay 200% F&A? So when Hank came, Hank said, that's crazy. I'm paraphrasing, but you're like, it's crazy. We need to fix that. So we did. We got all campuses involved, and we've removed that clause from BPM 203 that allows us to enter into contracts with industry and not protect our IP. I got the 5-minute. All right. Now, let's say we do enter into that contract. Everybody's happy. Industry signs it the same day we sign it. Is it ready to ink? Can I ink that contract if industry agrees to that contract? Not initially. If we're going to waive IP, the collected rules indicate that the president or this designee has to sign off on IP waivers. So we have an IP waiver form that we complete. Hank's the designee. We send that over to Hank. We've tried to streamline that process, simplify the contract, simplify the IP waiver, that we can get these done very quickly. But if we send Hank that standard agreement with the proper signatures, he's going to sign off on it, and it's going to be pretty quick and seamless. All right. $1 million question, how long does it take? If we sign the standard agreement, it can happen pretty quick. If we have to negotiate different terms, whether it's IP or any of those other terms we talked about, that can delay the process to get a contract in place. But what I do want to emphasize is that OSPA, we recognize that industry wants to get contracts executed quickly. So we're going to do everything we can to speed up that process, work with our investigators to get those in place. How am I doing? 2 minutes? All right. All right. This is a slide. This is what I want you to take away from my presentation, or what I'm telling you is, again, a sponsor program's goal, we want to facilitate the goals and objectives of our PI. We want to assist. We want to be customer service based. We want to empower our investigators to make informed decisions concerning IP. So we're going to engage the investigators early and often to ask them, is there IP we need to protect? And we're committed to simplifying those procedures, creating new standard agreements, increasing communication with our faculty to facilitate our industry partnerships. Thank you.
Great, thanks very much. We have 2 minutes, so I'm going to try to fill it a little bit for you and say that this is one of the things that I think is really crucial for your understanding, and I want to reemphasize what Trey said. That is, if you're looking to work with corporations or industry as a sponsor of research, in the past, most public research universities and private universities had the stance that no matter who paid for the research, the university would own the intellectual property. And what we found over time is that that became less and less of a winning proposition, if you will, for allowing faculty who wanted to work with industry to do so. And there are a number of really nice things that happen in many cases when people work with industrial colleagues, and that is when you put theory and practice together, wonderful things happen. It's good for students. It also helps to inform the teaching of a faculty member, particularly in fields like engineering and the sciences. So there are good things that come out of those industry-sponsored research programs that go to support grad students, postdocs, and laboratories, and maybe even summer salaries for faculty. I certainly felt very strongly that way as a faculty member, and wanted to change it when I finally got the chance to do it. And I did at Penn State, and there was a general cheer around campus for making that change, although at the time we did it, we were among the first. In fact, we were the first, as far as I know, to do it. Not long after we made the change at Penn State, my good friend and colleague Eric Taylor, who's at Minnesota and is the president there, was also a Kennedy faculty member at Delaware and also faced some of the same challenges I faced, made almost the identical change at Minnesota. And that's now happening at many schools around the country. So let me tell you what it is again. It is a process whereby we engage you in telling us right up front, as Craig said, do you want us to negotiate for the IP rights? Do you don't care about the IP rights? Or are you unsure? And if you're unsure, and many times people are, then come have a discussion with us. And that's probably one of the most valuable things that can come out of this new approach, is that then it informs faculty about their own IP, what they might be giving up, what they might be gaining, what is the issue of background IP, how does that fit in. But it really opens up the opportunity for a lot of fresh air to come into the discussion. If you're interested, I wrote a paper on this while I was still at Penn State. I did a pretty careful analysis of all of our invention disclosures between 2000 and 2007. And out of what were 1,200 disclosures at Penn State of that period, fewer than 100, actually 92, came from industry-funded research. So it was less than 8%. And of those 92 invention disclosures, ultimately, I think there were 12 patents and 4 licenses. And I always like to ask, what do you think Penn State made on those 4 licenses? And I won't belabor it, but we made about $80,000. We probably spent 10 to 20 times that in pursuing those patents and licenses. And in addition, I had a pretty good analysis from people like Craig that we probably had pushed away 3 times as much industry-funded research as we actually had. So with all that in mind, with federal resources diminishing, with more emphasis being placed on transitions to the marketplace, it just seems logical for us to engage you in a different way and to engage industry in a new way. And that's what that's all about. I don't want to belabor it here today. separate discussion like this one later in December about industry-funded research, and I kind of call it the good, the bad, and the ugly. And we'll kind of go through that with you, and we'll cover again this new approach that we're taking. All right, with that said, I'd like to now move on to the University Tech transfer function, and I think we're going to hear from Chris Fender, sorry, my old Massachusetts accent just came back up there, apologize. Chris Fender and Lena Nedlick. Lena is in the, I almost said the general practitioner's office, but it's the general counsel's office as our new IP attorney. So, you're 2 minutes over because of me. Hurry up. No.
Okay. Thank you, Hank, and thank you all for coming today. I want to talk a little bit about a lot of what we've talked about earlier this morning has been kind of on the theoretical side, and what we do in our office is really where the rubber meets the road, so to speak, in terms of how intellectual property can be moved into useful products and goods that benefit people's lives and improve people's lives. And we sort of boil down what we do into identifying intellectual property, assessing that, protecting it if necessary, marketing those assets to a potential commercialization entity, and then ultimately negotiating a license that allows that entity to commercialize that technology. So the process starts with really identifying what is an invention, and really it's more than just an idea. Although the idea is the first step, conception of an actual idea. The part of the inventive act, the creative part of the mind that creates the idea is the first step in creating an invention. But there also has to be a second step, and that's reduction to practice. And how is that being able to describe how that technology is going to work, how that invention works, and being able to prove that it does work. And then you have to be able to, in a patent application, enable somebody who is skilled in that particular art area, to reproduce that work. And you have to be able to describe the best way to do that. And I'll turn it over to Lana, talk a little bit more about reduction to practice and what that means in legal terms.
Sure. When we think about kind of whether you have an invention or not, it's really where there's sort of a definite and permanent, in your mind, way to solve a problem such that one skilled in the art can actually make and use your invention. And when we talk about reduction to practice, we really think about it in two ways. One is actual reduction to practice. Have I made the device? Do I have experiments? Do I have data? But sometimes it can be constructive reduction to practice. So simply the idea of constructively writing the invention down through figures, through, let's say, chemical schemes in the patent application can sometimes be a way to meet that reduction to practice requirement. And it really does differ depending on the art area, the technical area that you're dealing with. So, for example, in the biological arts, in the chemical arts, if you're talking about, a treatment method, usually you're going to have some sort of in vivo data or in vitro data, maybe even in vivo data to truly invent. If you're talking about the mechanical arts, it may be simply enough to have a CAD drawing that sort of gets you going. So it really is sort of technology by technology, case by case dependent.
Thanks, Lana. And so if you get to the point where you've identified, you feel like you have an invention, you can satisfy those requirements with a result from your research, the next step is actually the invention disclosure process. And this is a formalized process where a form is filled out where you describe about your invention, the things we just talked about, the conception of the idea, the reduction to practice, and being able to allow an assessment to be done as to whether or not that is potentially patentable and commercializable. The invention disclosure process is also really important because There's ways to describe whether or not there would be bars to being able to get a patent from prior publications, which was talked about a little bit earlier today. So there are statutory bars. AIA is the American Invents Act. Have you published this in any ways presented at a conference, even through an abstract or a web posting? Could all provide a bar to being able to get patent application. And then we need to know how the invention was supported. Craig mentioned the Bayh-Dole Act and federally sponsored research. That's important. If it was industry-sponsored research also, it's very important that we have to identify that intellectual property so that we can, if we've agreed to waive the rights to the sponsor, that we can identify those and do that. It may have been funded by a consortium. There may have been a material transfer agreement, an MTA, that provided material that you used in your work that may have had conditions around it as well. And you have to be able to describe what is the commercial potential. We've talked a lot about getting intellectual property, and we can get intellectual property, but does it have value in the marketplace? And what is somebody going to be able to commercialize that, as Luis talked about, developing a technology into an actual product? And so having some idea about the commercial potential, who potential licensees might be, whether or not they're existing companies or startup companies or investors, and who else is working in this space? What other prior art might exist from others in this space that are developing innovations? And then finally, it's important to determine who the contributors are or inventorship. Some of those could be students. Students have a different set of policies, as Scott talked about, than faculty do, or employees of the university. You might have collaborated with others outside the university that might be inventors as well, and so that's very important to be able to identify all those things in the invention disclosure process. So what happens when an invention disclosure comes in? Once we get the fully signed and completed invention disclosure form, we enter it into a triage process where we review the funding. We work with Craig's office to get any contracts that were negotiated that were identified in the invention disclosure form so that we can look at those. It was federally funded. There's an amount of compliance that we have to do in the Bayh-Dole Act for federally sponsored research. And after that process, we identify any bars to patenting, as we talked about. We enter into really a parallel process of patentability analysis and marketability analysis. And in the patentability analysis, we have to look for being able to satisfy the conditions of getting a patent. Is it useful? Does it provide utility? That's usually a pretty easy requirement to satisfy. Most things that we're doing them because they have some utility. But however, novelty and non-obviousness are two that can become a challenge if there has been prior publications or there's been a lot of description of this particular area in what is called the prior art, and it would become obvious to someone skilled in the art to have combined those elements to form that invention. And so we look at those things, and then again, as we talked about, making sure it's been reduced to practice, that it can be described, and somebody who, an entrepreneur or a company, can look at that and determine, yeah, we can build on that and develop an actual product. And then again, that speaks to enablement, being able to accurately describe how you do that. And then we look at the market. We look at the market size. We look at barriers to entry. If your invention is maybe in an isolated area that's surrounded by a company's entire portfolio, that's going to be a barrier to entry. That's going to limit the amount of people that would be able to license that. And then, what is the competitive advantage? How does it create a product that is already in the marketplace, maybe cheaper, faster, better, and look at that. And from that, we arrive at a set of strategies. How are we going to, what's our strategy for protecting the intellectual property? And then who are the likely candidates for licensing? and then from that we can develop a strategy for marketing. So we've decided to file a patent application. Again, I'll turn it over to Lana to describe a little bit about the process of actually filing an application.
Sure, and oftentimes the context in which we first file comes about because there's going to be an upcoming publication, and so I want to make it clear that publication is important. Everybody needs to publish, and all of these sort of procedures are in place to ensure that our faculty members can continue to publish. But really, the first step is sort of faced with a publication. What we often do, not always, is file an in-house provisional patent application. And there's actually staff in Scott's office, in the Office of Intellectual Property Administration, who does that preliminary provisional patent filing. That sort of starts the clock, and there's a one-year clock to actually convert that provisional application to a non-provisional application. And during that year window, it's really Chris's office who sort of does maybe a little bit deeper dive into whether the invention is patentable in light of the prior art, or whether the invention is commercializable to any extent. But then assuming we want to move forward with a non-provisional application, we actually engage outside patent counsel to draft that. We've got about 15 or so law firms that we use. There's a statutory preference to actually use Missouri law firms, most of which are sort of in the Kansas City or St. Louis region. But really there's a lot of interaction and give and take between the inventors and Chris's office and outside patent counsel to put that patent application together. So what's in the patent application? Dennis talked a little bit about it this morning, but really the name of the game is the claim, right? There are these numbers paragraphs at the end of the patent application that really try to, in words, define what that invention is. And Dennis alluded to it this earlier. There are really sort of two competing goals in sort of drafting those claims. One, we want to try to draft the claim as broadly as possible so that we can kind of avoid design arounds, right? The other sort of objective is to not get too broad, because if we get too broad, then we start reading on encompassing the prior art, and we're not going to be able to get those type of claims through the patent office. And as Dennis mentioned, too, we typically sort of start with a number of different claims, and then during the patenting process, there's kind of a give and take going back and forth with the patent office, where we make arguments, amend the claims, to where we sort of finally come out with what is the patentable invention. So what else is in the patent? In addition to the claims, there's what we call the specification, and really that is all of the experimental work that the faculty members done, their supporting data, drawings, figures, etc., that sort of support what it is that you're claiming.
Thanks, Lana. I'll go quickly now. We're running a little bit short on our time, but we talked a little bit about the strategy that we would develop from the analysis that we would do, and typically after we've protected intellectual property, we would begin to look at these factors of how we want to move that technology in the marketplace. And it's a very, it's a team effort between the inventors, between us, between potential investors, entrepreneurs, trying to identify these things and being able to actually put the technology into the marketplace through a license agreement. And so the pathway looks really like this, and there's a number of different pathways that intellectual property can go down from this strategy once this is developed. Oftentimes, if we protected the intellectual property, we're going to market it. If it still needs additional research, then maybe we'll wait for that research to come in and do a reevaluation. If the marketing is successful, we can license it. Maybe we'll continue marketing, or if it's not successful, then maybe we waive the rights. We can also make those decisions earlier on based on the strength of the potential intellectual property as well. And sometimes if it's a sponsor that we've negotiated a right to license with, we'll just move straight into licensing. And then we also work a lot in monitoring those licenses and maintaining those relationships with commercializations. And just to give you a little bit of flavor about the size and scope of what we do in our office, it is a lot of work, and there's a lot of things, great things going on around here, and it's resulted in a lot of exciting commercialization opportunities that are happening right now. And, this is exciting to me that over the last 10 years, products that incorporate MU technologies have exceeded sales of over $1 billion, and we can document that from the reports we receive from our licensees. And nearly 78 million, actually a little bit more than that. This was at the beginning of FY14, have been received by MU, and as as the policy stated, 33% of that goes straight to the inventors, and so that's an incredible incentive for people to participate in the process. And none of that would really be possible without the collaboration we have with the Office of General Counsel, and Lana can talk briefly about some of the support they provide.
Sure. The Office of the General Counsel, our role is really to provide legal advice and support to faculty members and to Chris's office. I mean, with respect to tech transfer, Chris's office is really doing the day-to-day, the heavy lifting, and we're just really in a support role. But some of the things that we work on are all of the sort of agreements, whether they're with third parties or within the university. My background is in patent prosecution, so although there are sort of case managers in Chris's office that handle the day-to-day prosecution, I'm sort of the patent prosecution help desk. People, ask me if there's a particularly interesting question, or maybe on commercially important cases, I'll get a little bit more involved. And then I'll, just do general IP advice. It may be anything from ownership to inventorship to all sorts of things. But that's basically what we do.
Hey, great job, you guys. We're going to hold you up for 1 second.
Sure.
And I don't care if it's Chris or Lana who answers this, but a lot of times faculty will be engaged actively with grad students. And it's all over the place with respect to how people, as faculty members and grad students, come together around disclosures of inventions. And I know we've got some grad students here, and I've seen cases where some faculty members say, I'm the sole inventor, and they aren't, right? Because there's good evidential material in the laboratory notebooks of the students that shows that they were co-inventors. And I've seen other cases where faculty members are so magnanimous, they say, well, we were all inventors, and they're not, because there's not evidence to show that, in fact, they were. So I wanted you to speak to that issue because patent validity is threatened by not getting that quite right. Just a minute or two.
Sure. I mean, you sort of teed up the question with the answer almost in the question. So for a patent to be valid, only the inventors can be named on the patent application. And inventorship truly is a legal determination. So just because somebody is an author on a paper doesn't make that an inventor. Just because somebody in the lab is actually kind of doing the actual work but didn't have a contribution to conception of what the actual invention is, that doesn't make him or her an inventor. And I will tell you, if a patent ever goes to litigation, inventorship is one of the things that the infringer will often look at, will sort of try to pick apart and make sure that inventorship was indeed appropriate. So it's just really important to do it right and not do it for other reasons.
Very good. Thank you, Chris. Did you want to add anything to that?
No, I think Lana covered it really well. It is really important, and I would say that again, authorship doesn't automatically exclude people from being an inventor, but what happens is you see papers with 8, 10 authors on it, if we get an invention disclosure with 8 to 10 people on it, it is something that we really need to look at to make sure that everybody did actually contribute.
So authorship does not equal inventorship. Thank you both very, very much. This is now working. Oh. So I have to use a smaller voice now. But I'll use a big voice to introduce my new friend and colleague who works so closely with us and actually isn't a theorist on all this stuff. He actually has done it. And that's Bill Turpin. Bill, the floor is yours.
Do I need the mic? Not really? I should stand here? Okay. So I'm kind of new on the job. I just moved back from California over the summer, and that's why I dress funny. I haven't learned to dress like everybody else here yet. But I'm trying to get used to the cold weather. I went to school here, as Hank said, and then I went off and had a very rewarding career, 10 years in Texas, 25 years in California. Along the way, I started a lot of companies. Some of those I self-financed, basically with no money. Some I raised angel money. Some I raised venture capital from the big firms in California. I've bought companies. I've sold companies. I've had some great successes. I was there. I was an executive at Netscape when we IPO'd in 1995, so I got to ride that roller coaster up. Next company I did, we hired 50 employees, and we laid them off all one day and shut the company down the following day. So I've had a variety of experiences. And my role here, the reason I'm here is to share my experiences and to help everyone else get into that entrepreneurial thing. And so I have a whole organization over at the incubator that helps do that. Just to tell what the incubator is, I have a little story. I was talking to a lady who's actually on faculty here at a church function, and she says, I drive by the incubator, by the research reactor over there all the time, and I just wonder what you guys do in there. Is it some sort of temperature-controlled chamber where you grow chickens? Because it says Life Science Incubator. But turns out what we do is we help companies. So that the analogy is what you would do in an incubator for an animal, we do for a company. So we help a young company survive and prosper and be ready to go out into the wild. And so I got two main messages. One is you're not alone if you want to start a company. We have the incubator, and you can see we put the entrepreneur in the middle there, and we try to surround the entrepreneur with everything else the entrepreneur needs. So a lot of them need funding. We can help write research grants, phase 2 proposals. We can help raise venture money. Sheila Grant actually came and started talking to my predecessor, and he's the one that helped her find Luis to be her CEO. So we help bring in help. We provide office space over there. We have lab space to do continued scientific experiments. We have legal resources we can bring in and all of that. So my main message is if you've got an idea but you're not sure that you have all the skills and all, that's just come talk to us, and we can help do a pretty quick evaluation to see whether there's something there and then help move you forward with it. Let me go to this one. Our historical sweet spot has been life sciences. That's why it's called the Life Science Incubator. We have people working on therapeutics. The hair on the back of my neck was standing when we were talking about replacements for antibiotics a minute ago. We have a company in the incubator now that's actually potentially has a whole new way of doing antibiotics. We have a company that's trying to figure out how to turn cellulose into jet fuel. We have companies that are working on crop enhancement. We have all kinds of interesting opportunities over there that we're working with in addition to Luis's company with the dermal fillers. A lot of nano engineering companies we work with as well. My experience has been in the software, digital media space, and so we are extending and branching out, and we're going to start doing more things. We have a world-class journalism school here at the university, so I'm looking for new media advertising businesses that we can help. Medical informatics, I'm working with the College of Education on online storytelling and other initiatives out of education. Social networking, cloud services and all. So we're trying to really broaden it out to cover a lot more of the colleges here at the Mizzou and help startups come out of those colleges as well as the traditional medical school, engineering kind of things. So our typical engagement is, I don't mean to shortchange the parts at the top, but a typical engagement is it'll be a faculty research project or grad student project done at the university. They then work with Chris Finder's group to license back the patent that they've assigned to the university, so they have ownership. And then the part in the blue there is the part we help do at the incubator. It's creating the legal entity, creating a business plan, working with Chris to negotiate the patents, all those sorts of things. Initially, we try to create a product. We start the regulatory process, and we demonstrate success. Then companies that are successful graduate out of the incubator. Several have graduated out, like what's their name? Modern Meadows is now in New York. They do 3D printing of tissue. So we've had several graduates. Organovo is now in California. So we've got, but the part in the middle is the part we can help with. There's one more point I want to make with this slide. It's not on the slide, but the industry has changed a lot to where it used to be industry did a lot of their own research, particularly in pharmaceuticals. And what Big Pharma has done recently is they do a lot less research themselves. They want to go out and buy startup companies that have proven that a therapy or a medical device works. I've talked to Chris about it. A lot less big pharmas are now interested in buying patents by themselves because the patents still involve a lot of risk. Will it make through FDA approval? Will it actually work? Is it poisonous? You know, things like that. And so the big pharma companies, I've talked to Mallinckrodt and a lot of the ones in St. Louis, actually want to buy the companies that are coming out of the bottom of this process. And they'll pay billions of dollars to do it, but they don't want to buy as much just the patents at the top of the process. So this creating a company and actually taking the risk out of it is kind of where the whole industry is heading, particularly in big pharma. And so if you have an interesting idea and you really want to see it make it into the world and help make the world a better place with people using it, I really want to urge you to consider going through this process to actually get it to where big pharma will want it. And all I'm here to say is we can help you with that process. I know it seems confusing. It seems like it's hard to do. But that's what we're here to do, is to help lead people through that process and hopefully get as many companies as possible out the bottom and working with big pharma, big IT companies, et cetera, to get that world-changing technology that all of you are developing out into the world to make the world a better place. So that's all I was going to talk about.
Terrific. Thank you very much. Appreciate it. Okay, I'm going to try to set this here and see if it'll sit here. At this point, I want to just tell you what we told you, tell you, and that sort of thing, right? So just a few minutes to wrap up here. First of all, I want to thank everybody who is here and was here for their terrific, sincere presentations. And, you know, I don't think I've worked in industry early in my career. I've worked at 3 different universities. I've worked closely with DuPont, Mobil, American Cyanamid, Air Products. I could go through the list. I never found a better team of people who are more sincere about getting the job done than this group at MU. So thank you very, very much. And I mean that. And I've got 35 years, I hate to say it, experience. When I look in the mirror, I'm like, who is that guy? But I do have it now. I guess that's a good thing. And I really mean it. It's a great group. We're in a new era. All right, so we're in a new era at federal, state, and local level. When you think about this, think about STAR metrics, and you know there's new pressure on us to prove that we can take the dollars that we garner in research productivity and convert it into economic lift. I have a whole talk on this. I'd love to give it to you, but I won't. Federal funding, obviously, I hate to say this, but it has stagnated. And in fact, in real dollars, it's going down. Even at Harvard University, they're having these discussions, and more of their research is privately funded rather than federally funded. And we all know academia, as someone once told me, is like a snake, where Harvard is at the head of the snake, and the rest of us just reptate in synchrony with Harvard over time. You may not accept that if you come from MIT, but for the rest of us, we do. It's a huge new emphasis from NIH on through to NSF on translation. And translation is really just the term du jour for converting the products of research into things that can lift the economy. Why do we care so much about that? Why is it one of our 4 pillars under our mission? That's because we have a huge social responsibility as a land-grant university. Well, those of us who are fortunate enough to work here at the university are very, very benefited by that. But there are a lot of folks out there who don't have those benefits. And today, in particular with the way this economy works, really need others to help create jobs that they can then fill into and do great work around. So to me, I think it's a social responsibility, and I'm passionate about it from that perspective. Next thing is, you know, when I started my career, I kind of knew what intellectual property was because I'd been in industry. But most of the time, we didn't worry too much about it. Most faculty haven't worried too much about it, particularly if you're my age. It's a new era. It's important to know about these things. We'll run this program again next semester, and probably in the fall and the spring again next year, until people tell me we've heard enough. Don't do it anymore. We're sick of it. But we'll always have new faculty coming in, and so even if it's a small group, we'll still do it because I think it's really, really important for us. The other thing to remember is, you know, again, speaking from the perspective of spending the first 4 years of my career in industry, you know, in industry, every week I had to write a report on what I had done in the laboratory that week, and then I had to summarize that as a monthly, and then a quarterly, and then an annual. My administrators knew every single thing I was doing all the time, all right? It's very different here. You have agency in all of this process. You make the decision whether or not to disclose something as an invention or to publish it, as Steve Wyatt was saying. There's no punishment involved if you choose to publish and not to go forward with an invention disclosure. No one can and no one will ever force you. We may encourage you, we may cajole you, but we'll never force you. You have the agency, you have the academic freedom to make that decision, and that's crucial. I don't know and never will know all the things that are going on in the laboratories here, the way management in an industrial research context does. That's fine. So it's important for us to convey this to you and to also convey to you that not that much has really changed. It's just a matter of we need a few good volunteers to help us do this. I also wanted to say that we're going to have several more of these. I think I already mentioned that we have 2 more coming up in December. Is that right, Gloria? Oh, gosh. Yeah. Okay. So in December, we'll be doing industry-funded research. Actually, that's an 11. So we'll be doing that soon, talking about that. And again, some of this will be a repetition of that which you've heard today, but that's okay. Please urge your friends and colleagues, if you liked this today, to come to these meetings, because I think the more people we can get together thinking about these things and self-educating, the better off we'll be. Invite graduate students and postdocs to come as well. So this is really our attempt to try to kick that off. And then the last piece will be on entrepreneurship on 12/18, and we'd love to have you here for those discussions as well. Okay, with that, I'm going to now turn to you and say we have a few minutes left. We've given a lot of feed forward, and I understand that, but we did leave a few minutes for you to ask some questions, if you have questions, and we'd love to hear those questions. And I'll keep talking until someone gets up and walks to the microphone and actually wants to ask a question, or maybe we could even move the microphone around. And if there aren't any questions, that's okay too if you want to wait and come up later. But it would be fun to have a few questions. As I said, I'll keep talking until we get one to encourage somebody. And so you may want to stop me at some point, but I won't stop until somebody has the courage to come forward. Yes?
My question is about the AAU. So for
The AAU, the American Athletics Union, or the American, the Association of American Universities?
Yes.
Yeah.
What advice do you have for research faculty
Yeah.
who are sharing their research plan that may be going towards this entrepreneurial direction with department chairs, research chiefs, that are concerned that going that way won't do anything to help us maintain our standing in the AAU, and there's this pressure on to do the types of accomplishments that are more recognized?
So send those folks to me, because on the contrary, it'll help us tremendously with AAU. And the way that works is this. We've got a 5-point plan. I'll go over it with you if you'd like, but you can find it on the web. That 5-point plan is there to try to drive up our numbers in the AAU. The biggest number in the AAU that they look at when they try to make judgments about universities, fair or unfair, is how much research expenditure you have from federal competitive grants per faculty member with tenure or on the tenure track. That's where our numbers are low, and this strategy is meant to help kick those numbers up, frankly. And part of the reason for that is we're ahead of the game in understanding that these extraordinary new measures and metrics are going to be entering into decisions from NSF to DOE to NIH about which schools and which people to fund. So if you're at a school that has a good reputation in this area or an excellent reputation, frankly, at the last hour, when they're making the last decision about this school or that school and this person versus that person, they're going to win. All right? So it's imperative for us to get that point across. Now, I've spoken to all the deans about this. They tell me they get it. I think they do. I haven't gotten down to the level of department chairs yet, but you know, I'm all for the idea of going to individual dean's councils and talking to chairs about it too. So thanks for that question. It's interrelated. By the way, the same things that are going to help us with the AAU will help us with the federal agencies, will also help our reputation in the state and with state funding. Good question. Thank you. There are no bad questions at this point. Mark.
Yeah, just a comment. I thought this was a great session, so compliments to everyone who spoke, and I would assume the next two sessions will be equally informative. You mentioned in your summary comments that people of our age, I'll include myself, may not ever make the conversion, but there are a lot of young faculty who we really want to reach. So I wonder if we could develop a program, perhaps an abbreviated program, that targets junior faculty and does it as part of a orientation for new faculty.
Everything is possible, so sure. And we're open to other suggestions on how to do this. This is our first one out of the box, and we're trying to figure it out with you. So let us know, and that I mean that for everyone, how we could do it better. Is this the best time of day? You know, we tried to give people with kids a chance to get here by 9 o'clock, you know, but maybe I doubt it's better in the evening, but it could be. I don't know. But we're open to these ideas. And if I understand correctly, this has been videotaped. So to the extent that we've got reasonable audio, you can point faculty to it. And we're all open. We want to have those discussions with folks. You make a great point, though. The millennial generation, I hate to use that term, loves this stuff. I mean, they really love the idea of entrepreneurship. Other questions? And you can ask these folks questions, too. Yes, in the back.
Hi, sorry, back. Sam Ish from the Tech Transfer Office. In addition to what I heard today is that we are trying to build companies, and Bill is obviously helping with that. I've seen in a few instances where there are companies of various sizes, but mainly smaller companies that are looking to the university for some sort of infrastructure or help with their own company. It may not have come out of here, but it may be in the state or elsewhere. So who, you know, when they come in and they're not necessarily sure, they know they need help with something, and they're looking to the university to help in that, but they're not necessarily sure where should I go or who should I talk to. So who in this process is showcasing what we have to those companies that are from the outside and looking into us?
So I'm not going to answer this one. I'm going to ask Steve Wyatt to answer it, because with the recent changes in our office, we're going to be creating an office that Steve will be operating to do just that.
Thank you. And a little bit of it depends right now on what they're wanting. And so what we hope to do in the future is create, by pulling a lot of these resources together, what we kind of casually call a business engagement office, so that individuals that are wanting to engage with us can go to a place to identify what their needs are, and then we will work on the back end to get them to the right location. That does not exist today. However, what I believe we can do is say that there are several doors that they can go to help them navigate. So if they're primarily looking for business assistance, or they're looking for a location, or some of those kind of general business, there's several places they can go, and two doors that would be pretty easy. One of them would be Bill Turpin down at the Life Sciences Incubator. The other one is there is the Small Business and Technology Development Centers. They have an office in the College of Engineering, and also downtown at Ready, the parking garage. There's plenty of parking there. But they also have counselors down there. Any one of those stops is a good place for a business to start the discussion around business. If they're wanting to look about licensing, of course, the OTMIR. If they're wanting to deal with a contract, we can work them through sponsored programs. And you can send them to me as well, and we'll try to get them to the right spot. So the intent is there's several doors right now. All of those groups are trying to work very closely together to help people to get the right assistance, and we are going to work long term to make it even easier. And I'll let Bill add a few things to that.
Yeah, I only have a little bit. It is confusing, and Steve and I are working together to unconfuse it. The incubator has a charter, though broader than just helping Mizzou. We're supposed to help the community, Columbia College, and other people. So we aren't just university focused. And obviously Ready downtown is another big resource. But if anybody comes to me and we're not the right resource, we refer, and Ready refers to me. And so it doesn't really matter too much which door you come in, as long as you go into some door and ask.
Chris, did you want to add anything to that? I would also just add a little bit about extension here. I see Mr. Devlin back there. And I'd really like to thank Mark that as we go forward in time, both extension under engineering and extension under agriculture will become even more a part of this process, and will help us to get information out and needs back in. So we do that translation piece even better than we do it now. Other questions that folks may have? Yes.
So my question's a little bit selfish, but hopefully it'll apply to some other people here. As a yet-to-be-to-reach tenured faculty, innovation and entrepreneurship is not something we typically see as part of the research, teaching, and outreach. Is that a misconception, or do you see that as being a bigger part of the tenure evaluation?
No, and there are people who've been here longer than I who can address this with you. I don't know which college you're in. You don't have to tell us. But I would say this question comes up more and more and more to me about, as we go into this new era, and we are in a new era, do we think that P&T processes and evaluations will change? I suspect they will over time, but they haven't yet in most places. I think that's right. I'm looking at engineering and ag and medicine. So I think one has to taper what you do before tenure, but really that's only about a 6-year window. And then you've got another 34 years to go where you don't have to worry about that so much once you do have tenure. Where I find it interesting is, if we look in the arts especially, their portfolios, their dossiers are very different than dossiers in engineering or in the sciences, because they have that big piece, Brian, right, that has to do with creative works, their portfolio. And if we could somehow adapt that portfolio style to promotion and tenure, so that a person who has done other things, design work, for example, is one that comes up all the time in engineering. virtually no one gets tenure anymore for design work, and that's a shame. It's synthesis instead of analysis. So maybe over time, as people like yourself get tenure, and you become more active in the university, which is a partnership and which is a corporation that goes through time. None of us will be here for the whole extent of it, obviously. Maybe you'll change that, and your generation will look at that. But right now, I have to be honest with assistant professors and say, better talk to your department chair first, better talk to your dean. I don't want to see you go off track and not get tenure. I'd rather see you get tenure and then go full force after this stuff, if that's what your passion is. Okay? Anybody else? Mark or Bob, do you guys want to comment? Do you think that's reasonable? Jerry, you agree? Okay, good. We've got a few more minutes left. Okay. Was this appropriate? Sort of nods of heads. Was it valuable? Okay. Would you tell your friends to come to these from now on? Good. Please do that, and I appreciate it, and thank you very, very much. And wait, the best part. The best part. I can't read anything, though, because I've been looking at that light, Marcia. What am I doing? Marcia, I'm going to let you say it.
Oh, okay. For those of you that registered, we have a drawing. We have 3 different prizes. Tickets to a football game, the 28th, lunch at the U Club, and tickets to the concert series.
Okay, so am I the one who's pulling these?
And you must be present to win.
And you will make it. Okay, well, how do we know the person who raises their hand will be this person?
Trust.
Cameron Pervase. Cameron?
Woohoo!
Woohoo! Cameron, since you were first, you get to choose among the 3 different gifts, unless there's a priority order, Gloria or Masha.
Whatever they'd like to do.
I would have taken that one too. Is that this one? Okay, great. Okay.